an alumnus of Government Law College Ernakulam, he has served as the Standing Counsel for the Kerala State Cashew Development Corporation. Following his tenure at the Kerala High Court, Justice Joseph continued to contribute significantly to the judiciary as a member judicial of the Armed Forces Tribunal, Principal Bench, Delhi. Your expertise and dedication surely promises this discussion to be insightful. We wholeheartedly welcome you, sir. Further, I introduce Professor Dr. K.C. Sunny, former Vice Chancellor of the National University of Advanced Legal Studies and a distinguished academic with extensive contributions to legal education and policy reform. Sir began his teaching career in 1986 and has held various roles at the Department of Law, University of Kerala. Dr. Sunny's international engagements include chairing multiple editions of the annual International Conference on Law and Public Policy in Singapore, observing elections in Nepal and Bangladesh, and delivering lectures at prestigious foreign universities. With a certificate in International Humanitarian Law from the International Institute of Humanitarian Law, Geneva, Dr. Sunny has authored over 60 publications. He has chaired the Committee for Industrial Law Reforms by the Government of Kerala and currently serves on the Advisory Committee of the Kerala State Higher Education Council. We wholeheartedly welcome you, sir. I introduce our third panelist, Professor Dr. G. Mohan Gopal, a distinguished scholar and authority in the realm of law and judicial administration. Sir has served as the director of the National Judicial Academy of the Supreme Court of India and has also served as the founder chair of the National Court Management System Committee of the Supreme Court of India, pioneering advancements in court management practices across the nation. He has also held the esteemed position of Director, Vice Chancellor at the National Law School of India, Bengaluru. A dedicated advocate for judicial and legal reform, Professor Gopal continues to actively engage in addressing contemporary judicial and legal challenges, furthering the cause of justice and institutional integrity. Unfortunately, he had met with an accident recently. However, he has kindly consented to join with us online. We wholeheartedly welcome you, sir. I also introduce and welcome the moderator of the session, Mr. Manu Sebastian. Sir completed his LLB from Symbiosis, Pune, and served as an advocate at the High Court of Kerala before assuming his current role as managing editor at LiveLaw. He is known for insightful commentary on public policy and legal matters, with a focus on the Insolvency and Bankruptcy Code and constitutional law. We welcome you, sir. Now, before we proceed further with the conference and the panel discussion, the College Union 2023-24 humbly requests all the participants to kindly raise and to observe a moment of silence in solidarity with Palestine. Now, I call upon Zanan to present a resolution on the Palestinian genocide.
We, concerned scholars and students, affirm our unequivocal support with the Palestinian people. We heed the calls from Palestinian universities, trade unions, and movements for global solidarity and an immediate end to the genocidal violence in Gaza. Palestinians refuse to surrender to subjugation and elimination in the face of 75 years of Israeli settler colonial dispossession, ethnic cleansing, military occupation, and apartheid. Since the beginning of this latest onslaught, Israel's carpet bombing of Gaza has killed more than 31,184 Palestinians, including over more than 13,800 children, and injured 72,889 according to local health authorities, as of April 2024. Genocide is made possible through the racist dehumanization of Palestinians. We therefore urgently call for an immediate end to the Israel's genocidal campaign in Gaza and settler violence occurring throughout all of historic Palestine. We call on the world governments to stop aiding and abetting Israel through its military, economic, and political support and active participation in the dehumanization of Palestinian people. We support ongoing efforts to hold all those responsible accountable for war crimes. Further, we echo the call from Palestinian trade unions to stop all military support to and trade with Israel. Israel stands as an ongoing settler colonial project, and we demand recognition of the right to resist Zionist settler colonialism, Israeli military occupation of the Palestinian and Arab lands, and Israel's entrenched regime of the apartheid and racial domination. The National Conference and the College Union of 2023-2024 of Government Law College Ernakulam reject the attempts to silence solidarity with Palestinians and hereby reaffirm our support for the victims of war crimes in Palestine.
Those who agree with the resolution may kindly raise your hand. Thus, the National Conference 2024 passes a resolution in support of Palestinians. Now, without any further ado, I request Mr. Manu Sebastian to kindly take over the session.
Good afternoon, everyone. I'm very happy to be present here and very happy and impressed to see the arrangements and the organization. First of all, I congratulate all the organizers and the students for organizing this function in a very effective manner and also for raising very significant issues which are very relevant in our current political climate. So elections are said to be the festival of democracy. And if India is the largest democracy in the world, then the ongoing elections can be said to be the largest festival of democracy in the world. And elections are significant because probably this is the only time when the common man, an ordinary citizen, feels valued, because this is the only occasion when an ordinary citizen can express one's opinion about the government and can choose the government which should be governing the country based on its past performance as well as the potentials. So regarding elections, I would like to quote a statement made by Justice V.R. Krishna in a significant judgment, which I think is very relevant and captures the significance of the participation of this common man. At the bottom of all tributes paid to democracy is the little man walking into a little booth with a little pencil, marking a little cross on a little lot of paper. Of course, I mean, this judgment was made during the times of ballot paper. So in the present context of EVMs, we can say that it's all about a little man going to a little booth and pressing a little button, which can change the fate of the country. So a free and fair election process is absolutely necessary to ensure that this democratic process is taking place in a very transparent and effective manner. So it is very essential that the choice expressed by the ordinary citizen is captured, recorded, and analyzed in a proper manner. So what can happen if the umpire, who is supposed to conduct the election and counting process in a fair manner, is not acting in a neutral manner? A little indication of this dangerous consequence can be seen from a recent case which happened before the Supreme Court. I'm talking about the Chandigarh mayor election, which happened in January. I'm sure all of you have read about it. So what happened in this case was that, so it was basically an election to the post of mayor of the Chandigarh Municipal Corporation. Not a very significant election in the larger scheme of our country, but still, what can happen if the election process is manipulated? That is very evident from this case. So in this case, the presiding officer, who was aligned to the BJP, he was supposed to count the votes and declare the results. So he deliberately defaced the ballots which had recorded the votes for the opponent candidate. And the matter reached the Supreme Court. And the Supreme Court did not hesitate to make a strong intervention, and the court counted the votes and declared the results by taking into account the defaced ballot papers. So what was significant in the case was that the mischief committed by the presiding officer, that was captured in the CCTV cameras. So the evidence was very clear. So the court had to merely go through the records, the CCTV footage, and declare the results. So what if the CCTV cameras were not there? What if it was happening under complete darkness? These are all very pertinent questions. So to borrow a metaphor from this event, I would say that in the context of the current general elections, we are like the CCTV cameras who should be exercising constant vigil over the authorities to ensure that they are not faltering in their duties. So, like, there are several questions about the role of Election Commission, and we'll be discussing that elaborately in our session. So whatever little actions Election Commission has taken, even after much time, all those actions came due to a lot of public pressure. So it is very much important to raise our voice in whatever small forums we have, be it in social media or other public platforms. Each voice counts, because authorities, at least, they'll be fearful of the public opinion, and at least for namesake, they'll be doing something. So this eternal vigilance is the price we have to pay to ensure that our democratic process stays in a very healthy manner. So without wasting much time, we'll get into the discussion. We have a very distinguished panel here. We have Justice Babu, Mathew Joseph, Professor K.C. Singh, as well as Professor Mohan Gopal, who is joining us virtually. So I request Justice Babu, Mathew Joseph, and Professor K.C. Singh to come to the dais so that we can initiate our discussion. So in March 2023, the Supreme Court had delivered a very landmark judgment, holding that the appointment process of election commissioners that should be independent of the executive control. And since no law has been enacted to streamline the process of appointment, the Supreme Court suggested an ad hoc measure. The court directed that till a law is made by the Parliament, the appointment of election commissioners should be carried out by a panel, a panel comprising the Prime Minister, the Chief Justice of India, as well as the Leader of Opposition. So the court deemed that the presence of the Chief Justice would ensure that there is some degree of independence in the election process. So I would like to know from Justice Babu Mathew Joseph, since he was a member of the judiciary, do you think that the presence of a member of judiciary in the selection panel can ensure that the appointment process is independent and fair?
Definitely, my answer is 100% affirmatively. The beautiful judgment rendered by the Honorable Supreme Court by the Constitution bench comprised of 5 judges, including our Justice K.M. Joseph. I have made an attempt to go through, but I could not fully go through. But the salient features of that judgment I could go through. The founding fathers of the Constitution wanted to see that a 100% independent and honest election commission should be there for a successful, beautiful democracy. Article 324 gives sufficient power to the election commission. And regarding the appointment, Article 324(2) said, election commission is the authority but subject to the law, subject to the provisions of the law made by the parliament. But while considering this aspect by the Honorable Supreme Court, the Constitution bench surveyed the entire aspects. The discussions took place in the Constituent Assembly, the will of the Constituent Assembly, the will of the founding fathers, and one who goes through the judgment will get a definite impression that the selection of election commissioners, chief election commissioner, as well as the election commissioners should be made by an independent body, and in that body the Chief Justice of India should be there. That was why the Honorable Supreme Court had shown a model of committee comprising the Prime Minister of India, a Union Cabinet Minister, as well as the CJI, Chief Justice of India. But not ignoring, thwarting the will of the judgment, an enactment has been passed by the Parliament at the instance of the Union Government, Appointment and Conditions of Service, etc. Act, in which there is a search committee and a selection committee. Search committee is headed by Union Law Minister, and the two secretaries will be members of that committee. They will submit a panel of 5 persons, and out of that panel, Chief Election Commissioner as well as the elections commissioners can be appointed. Curiously enough, strangely enough, why an unbridled power has been given to the selection committee? The selection committee is comprised of Prime Minister and a Union Minister chosen by the Prime Minister and the leader of opposition, or in his absence, the leader of the largest party in the opposition will be members. So, the Prime Minister and the minister appointed by him, they form the majority. Not only that, there is a search committee. That search committee is empowered to give a panel comprising 5 persons, and this selection committee even can reject that panel. They can ignore and they can select some other person. That is the provision. Am I right? That is the provision. Such a strange law has been enacted by the Parliament at the instance of the present government. This is not for doing any justice to the parliamentary democratic system envisaged by the Constitution of India, or the will expressed by the Honorable Supreme Court for the well-being of the democracy in our country. This is only for protecting, only for subserving the union government by the election commission. That in fact happened. What is happening now? April 21st, the Prime Minister of India, for your, 1 second. Corrupt practice Section 123, 3A. A reading will be useful. The promotion of or attempt to promote feelings of enmity or hatred between different classes of citizens of India on grounds of religion, race, caste, community, or language by a candidate or his agent or any other person with the consent of a candidate or his election agent for the furtherance of the prospects of the election of that candidate or for prejudicially affecting the election of any candidate. That is one of the corrupt practices listed in the Representation of People Act 1951. And based on the Representation of People Act 1950 and 1951, the Election Commission itself have formulated a model code of conduct, and in which do's and don'ts have been specifically listed. Among the don'ts, number 5 says, caste, communal feelings of the electors shall not be appealed to. 6, no activity which may aggravate existing differences or create mutual hatred or cause tension between different castes, communities, or religious or linguistic groups shall be attempted. What happened? What happened in our country during the last about 1.5 months? The most important office holder himself comes forward and raises baseless and violating this, committing this corrupt practice, violating this code of conduct, delivering speeches against which complaints have been given by the opposition parties to the Election Commission. That has not been attended to, and after a month comes with an order. Not even a notice has been issued to the person against whom that allegation has been made. Not even a notice. And in the order ultimately passed by the Election Commission, not even a mention of the name against whom that order is issued. What a type of commission it is. Because, I am not explaining further, for more than 1 month regularly, despite the fact that several complaints have been given to the commission, commission simply kept quiet, ignored the complaints, and allowed the person who committed the breach, who committed the corrupt practice, who committed violation of the model code of conduct, allowed to continue his hate speeches and for creating differences among classes, different classes on the basis of this religious communalism, etc. That is what happened in this country during this last election campaign. This is not, we cannot appreciate. I am a citizen of this country. I believe in democracy. I believe in the Constitution of India. I believe in the principles enshrined in the preamble to the Constitution. This is a secular nation. What is the importance of secularism? This country does not have any particular religion. This country doesn't have any particular religion. Maybe the people in this country may have their own religions. That is allowed by the Constitution. But India doesn't have any, as the rulers do not have any particular religion. The Constitution does not permit that. You see, what happened in the matter of Parliament opening ceremony? What happened in this Ram Lalla? What happened in the campaign? What happened? everywhere the topmost man who is wielding power has been showing a very, very bad picture, violating the fundamental holy principle enshrined by our Constitution. Openly, what is the position in the eye of the position of this country in the eye of the world? Whether can we claim we are the largest democracy? Of course, we have 145 is the 145 crores of population, and around 95 crores of voters, and everything is there. But we cannot say here we are going to have a free and fair election under the present rule or under the present election commission. The Constitution, the constitutional principles are ignored or violated or transgressed. You see, preamble says India is a sovereign, socialist, secular, democratic republic. Secular means India doesn't have any particular religion, no official religion. Unlike Pakistan and Malaysia, we don't have any official religion. Not only that, even without the amendment and incorporating the secular in the preamble by the 42nd Amendment Act with effect from 3/1/1977, the principle was similar. India doesn't have any particular, India doesn't promote officially any particular religion. You go through section 25, that gives the right to worship, which says, what says? Which says, all persons are equally entitled to freedom of conscience and to freely profess, practice and propagate religion. So, those who are willing to believe in religion, you can believe. Those who are not willing to believe in religion, they need not believe. So, India doesn't promote any particular religion. You see Article 27 of the Constitution, which says, no tax shall be levied from any person, any citizen of this country for promoting or maintaining a particular religion or denomination of a particular religion. Then comes Article 28, 1 and 3. What does it say? Educational institutions. Those educational institutions run by the funds of the state. There cannot be any religious instruction of religious worship. And 28.3 says, an educational institution which is functioning with the recognition given by the state. State means not Kerala state, Karnataka state, Andhra state, no. State as defined under Article 12 of the Constitution. There are so many institutions, authorities coming under state. So, the authorities or institutions who are running this educational institute, granted permission to run educational institutions, or like our aided schools, aid is granted to educational institutions. In such educational institutions, without the permission granted by the students, if they are adults, they have attained majority, no religious instruction or no religious worship is allowed. If they have not attained majority, without the consent granted by their guardian, no worship is permitted. No religious instruction is permitted. Then you go to Article 51A, Clause E, transcending religious, linguistic, regional or sectional differences. You have to maintain this harmony and fraternity. All people should live friendly like brothers and sisters. Whether it is Hindu, whether you are Hindu, whether you are Christian, whether you are Muslim, or you are Sikh, or any other denomination, you are bound. It is your duty under Article 51A. It is a fundamental duty to live like that, to uphold the fraternity. So, Indian Constitution envisages this secularism, constitutional secularism. That is violated here, bluntly, that is violated by the people in power. I can expand, but my friends, I would like to mention one more fact. Among the panelists, Dr. Sunny is here and Dr. Mohan Gopal. They are experts really in this topic. I am not such an expert. If you give me this question for my decision, I will give you a verdict. That is a different matter. But they are experts. So you will get a vivid picture as far as these topics are concerned by their speeches. And I also want to mention one more. I was a student here, 1976 to 1979. And I want to mention one fact to my dear fellow students. I purposely use this terminology, my dear fellow students. Why? In 1978 last or 1979 beginning, the greatest lawyer ever seen by this country, none other than Nani A. Palkiwala, visited this institution and delivered a speech. Before delivering the speech, he addressed us, addressed the students, my dear fellow students. Like that, I am also addressing my dear fellow students. His speech was wonderful. It was a beautiful speech. I still remember. And during the course of this discussion, if anything I want to add, I will add. You please listen the wonderful speeches they are going to make on the topic. Thank you.
Thank you, Justice Babu Mathew P. Joseph. So Justice is saying that essentially the Election Commission is acting like a selective commission, selectively acting against opposition parties while turning its blind eye towards acts committed by the people in power. So I think the root cause of this selective nature of the Election Commission is the appointment process itself. And until and unless the appointment process is ensured to be independent, we can't have an independent Election Commission. So in this context, I would like to hear from Dr. Mohan Gopal. Sir, I believe you are audible. We are audible.
Good afternoon, Mr. Manu Sebastian, Justice Babu Mathew, and Professor Sunny. It's an honor to be in such distinguished company, and I thank you. I thank the wonderful students of Government Law College Ernakulam, especially the Student Union, for having taken the initiative to organize this event. And I apologize for being unable to be there. I had a small accident. The accident was not significant, but it deployed the airbag, and the airbag came and hit me. I was going at a very slow speed. The airbag hit me and created two small fractures in my ribs, two ribs. So that's why I'm required to not travel and not move. I'm at home. But I did not want to miss this event, and so I'm very grateful that the opportunity to participate has been provided by the students through this online mechanism, much as I would have liked to have been there. Mr. Sebastian, I hope you can hear me clearly.
Yes, sir, clearly. Sir, so I wanted to hear your perspective on this. So the election, as Justice Babu Joseph has explained, we had
Yes.
the Supreme Court judgment, and after the judgment, the Parliament passed a law, effectively replacing CJI in the selection panel with a cabinet minister. So now we have a committee comprising the Prime Minister, a Union Minister, and the leader of opposition, selecting the election commissioners. So the one argument in support, the government's argument to support this law was that the Supreme Court itself in its judgment stated that the mechanism suggested by the Supreme Court is an ad hoc mechanism that will operate until a law is made by the Parliament. So the Supreme Court itself has recognized the supremacy of Parliament in making a law to appoint election commissioners. And so there is no conflict with the Supreme Court judgment. This was the argument which was put forth by the government. And several petitions were filed seeking a stay of this law. The Supreme Court did not hear the matter immediately, and the matter was heard very close to the elections, when the court said that now we can't interfere because interfering with this law would upset the election process. So the court refused to stay.
There's a small gap in the voice coming to me.
Is it clear now, sir? Is it clear now? Sir, are we audible now?
Yes, I can hear you. I can hear you now.
Okay. So I just wanted to hear your perspective on this aspect, that whether this argument raised by the government that the Supreme Court itself has acknowledged that Parliament can make this law. So will that hold water? Will that is that sufficient to say that this law is justifiable?
See, I think it's a very good question, Mr. Sebastian, and as you know well, we have in the Constitution Part 15 that deals with elections, and it is very significant that this Part 16 is independent of the part that deals with executive, legislature, or judiciary. So it's a completely independent provision on elections. And there the Constitution in Article 324 very clearly provides that there shall be an election commission, that the superintendence, direction and control of elections to be vested in an in an election commission, which will oversee all the elections. So that's not optional, that is required by Parliament. And in Article 327, the Constitution provides Parliament to make law with provision to respect to elections to Lok Sabha, Rajya Sabha, or in certain circumstances, the legislature of a state. And so the court is right in saying that the court does not have the power to lay down the method of selection of the members of the election commission, that it is to be done by law passed by Parliament. The court is correct. And it is also correct that the Parliament passed a law. Now, that does not mean that the judiciary cannot test whether or not the mechanism, whether the law adopted by Parliament is in violation of the requirement in the Constitution under Part 16 that elections shall be, that the election commission shall be independent, and that is the very reason why we have a constitutional provision on election commission is that it should not be a matter of ordinary statute or legislation whether or not to have the election commission. And that is because the election commission has to be independent of the power of Parliament to whether to have or not to have an election commission, and that the election commission must be independent. Therefore, the Parliament is not free to come up with a statute that compromises with the need for independence of the election commission, because that is, I would argue, in a democracy, in our basic structure, it has been recognized as the Supreme Court democracy is a basic part of the basic structure of the Constitution. And in a democracy, independent, fair and free and independent elections are a part of the basic structure. And therefore, any law passed by Parliament must ensure that the Election Commission is independent. And in my own view, what the Parliament has passed is not a provision that meets the test of independence of the Election Commission. And simply by the presence of one person, a minority, and we've seen how it operates. The leader of the opposition has famously said how several, maybe a couple of hundred or some, I can't remember the exact number, applications were given to him with a few hours' notice, and he was asked to take a view on that. All this means that there is really no independence. So there is every reason why this law should be challenged and struck down by Parliament as unconstitutional, and although it's not necessary, it's not a constitutional amendment, but also as being against the basic structure of the Constitution. But that does not mean that the judiciary should be a member of the Election Commission. Personally, I don't agree with that. I think the judiciary should be free to and independent to evaluate the decisions of the Election Commission when petitioned by political parties or voters or contestants to see whether the Election Commission's decisions were independent. And if the Supreme Court is involved in selection of an election commissioner, that, I think in appearance, if not in substance, the independence of the Election Commission from the Supreme Court becomes questionable. And so I don't think that the Supreme Court should be part of any selection mechanism. That's not the job of the judiciary. The judiciary is increasingly being absorbed into executive functions, blurring the distinction between the judicial branch and the executive branch. So I think that's a separate issue. And I think the Supreme Court was indirectly indicating that it has no basis to say that it is only the independence of the presence of a judge that will make it independent, because we now have very openly stated examples of a judge taking very partisan politically partisan positions after he comes out of office and resigning in order to take a partisan position. So simply because someone occupies a judicial office or is an election commissioner or is a civil servant does not mean we can assume they're independent. That independence must be tested only through an adversarial process in a court of law, where judges, following the rule of law, will examine the evidence and the arguments presented by concerned parties to the court to show that decisions were not independent and be able to make an independent assessment of whether or not elections are being held independently. So I would say in summary that I think the Constitution does provide the power to the legislature to make that, to establish the procedure for selection, because it doesn't provide that in the Parliament explicitly, in the Constitution explicitly, to legislate on the method of selection of election commissioners. But once Parliament enacts such a law, then it is very much within the province of the Supreme Court to examine the constitutionality of that law, tested against the cardinal, fundamental, basic structure principle of the independence of the Election Commission, which cannot be compromised with.
Okay, sir. So essentially you are saying that there should be an independent mechanism, but the presence of judiciary in the selection process may not be ideal. But at the same time, the court has the power to review the law passed by the Parliament to test whether it ensures an independent mechanism. So what can be an independent mechanism is a very big question which is staring at us. So in this context, I would like to hear from Dr. Singh. So I understand that you have a lot of international exposure in observing elections in many SAARC nations. And so from your experience, what can be an independent mechanism to appoint election commissioners, and how the process can be shielded from executive interferences?
I am extremely happy to be the part of this discussion with these two eminent persons, Honorable Justice Babu Mathew P. Thomas and Dr. Mohan Gopal, former Vice Chancellor of National Law School and former Director of Judicial Academy. So, coming to the independent mechanism, before answering that question, there may be one fundamental issue. Why this election commission? For superintendence, direction and control of elections. Then, for this purpose, election commission is exercising executive power, legislative power and judicial power. That is categorically stated in Mohinder Singh versus Election Commission by none other than Honorable Justice V.R. Krishnaiah. So, person holding the position of Election Commission should have the capacity to supervise, give directions and control the election process. First thing. Secondly, he should have the capacity, that is competency, integrity and all these things, to exercise executive power, judicial power and legislative power. Last 5 or 6 years, we have election commissions. What is the level of their performance? Especially in the matter of exercising judicial power. The issue of judicial power mainly comes, quasi-judicial power, that is quasi-judicial power. That is basically, that is a judicial power. Only thing is that is exercised by executive authority. Anyway, that is to recognize political parties at the time of, to recognize the legislative party when there is a split or merger. Regarding this issue, there is one basic decision. That is, Northeastern Hill State Congress versus WS AGMA. Anyway, I am not WS AGMA versus Northeastern Hill Congress, Hill Conference or something like that. That's the issue was WS AGMA later became the speaker and union minister. He was actually heading a regional party. His party, PS AGMA, and his party merged. Anyway, that is the issue. Here, certain criteria, definite criteria, has been formulated by the Supreme Court. In several occasions, Election Commission applied it. And most of the cases are from Kerala also, because in Kerala certain parties are very much interested in splits. So there are so many cases from Kerala. Actually, this dictum is wrongly applied by Election Commission. Why? What is the process adopted? There may be hearing and all these things, but finally that may be a fire. That will be handled by the bureaucracy of the Election Commission. Finally, that may go to the Election Commission. Now, 3-member commission, there may be a sitting, but actually, a bureaucratic process is adopted by the Election Commission in this matter. So, without any hesitation, I can say that Election Commission is not at all competent to exercise judicial power as far as the earlier practices adopted by them are concerned. Same may be the position in the matter of legislative function adopted by the Election Commission. So, then coming to the selection process. Firstly, we may find out the competent persons. For that purpose, definitely there may be a committee. And now, a minor difference between the viewpoint of Honorable Justice and Dr. Mohan Gopal is the presence of a judge. I think in the presence of the sitting judges may be avoided owing to several reasons. But there may be the presence of the judiciary. That may be, as in the case of earlier practice of Lokayukta and State Human Rights Commission, may be a judge who served in the Supreme Court or in the High Court as the Chief Justice. Only thing is that I am not thinking that only Chief Justice, persons served as Chief Justices are competent and others are not at all competent, that is the issue, then choice is limited. Choice is limited. If any judge, there may be choice is very wide. Anyway, such strategy may be adopted. Anyway, the point is that there may be the presence of a judge, either a retired judge of the Supreme Court or retired Chief Justice of the High Court. Or may other judges of the High Court may also be appointed. Then there may be some commission, some condition, that is, he may have the experience in hearing election petitions or something like that. Then coming to the next stage, though in the selection committee there may be the presence of one member from the judiciary. Definitely there may be some nominees of the central government, maybe some independent selection committee, that may be the screening committee also. But most important thing is the process of screening. Firstly, there may be a shortlisting that may be made available to the public. I think same logic may be applied in the case of selection of the judges also. Who are in the panel? What about their biodata or curriculum vitae? What about their integrity? So now in United States, in the matter of selection to the judiciary, then there may be the scrutiny by the committee of the Senate. There anybody can submit evidence. So such things may be ensured because transparency must be ensured. That is my point of view.
So that was regarding the selection process of election commissioners. Now coming to the actual conduct of elections. So during the elections, once the elections are notified, the election commission publishes this model. The model code of conduct operates, and the model code of conduct has several conditions. So Justice Babu Joseph has explained, he has cited some instances where the election commission is selectively ignoring the violations of model code of conduct with respect to the ruling party members. At the same time, they are very zealously taking action against opposition parties. So for example, in the social media, the election commission directed Twitter to take down certain social media posts posted by opposition parties. But when it came to the ruling party, the action was taken very late. After the elections, after the particular phase of election, the action was taken. And recently, the Calcutta High Court also slammed the election commission for not taking action against the violations of MCC. So in this background, so what are your thoughts about the election commissioner's approach in enforcing the model code of conduct?
Mr. Sebastian, can you hear me, Mr. Sebastian?
Yes.
Can I make a very brief intervention on the first point, following Mr. Sunny's presentation or remarks also, which I largely agree with, but more for the students to point out particularly section 324(2) of, Article 324(2) of the Constitution, which sets out the specific provision that the election commission shall consist of the chief election commissioner and such number of other election commissioners, if any, not necessary, as the president may from time to time fix. And the appointment of the chief election commissioner and other election commissioners shall, subject to the provisions of any law made in that behalf by Parliament, be made by the president. So that's a very specific provision that empowers Parliament to make law on the selection of election commissioners. I just wanted to point out that specific provisions, especially to the students, for their, maybe they already know it. The second very quick point I want to make is there is a very simple mechanism for selection, and that is by consensus. You have the Prime Minister, you have the leader of the opposition, you have an independent expert, and only a person that all three of them agree can be appointed as an election commissioner. And so you have a very simple, but I entirely agree with Mr. Sunny that the procedure must be very transparent. The criteria must be laid out, not just the minimum qualifications, criteria must be laid out. And it should not necessarily only be bureaucrats and retired bureaucrats. It's now almost reserved for former IAS officers, this position, when there are very competent people in academia, in the judiciary. I'm no objection to having retired judges on the commission, because they're not sitting judges anymore, and many of them are very, very capable and competent and incredibly independent, and they're also expert in the procedure and methodology for ensuring independence. So I think their presence I would very much welcome. But the important thing is to have the qualifications and criteria clearly set out. A screening process, as Professor Sunny said, should be completely transparent, but the method of selection should be by consensus. Only if the Prime Minister, the Leader of the Opposition, and an independent person, all three can agree that this person should be an election commissioner, then at least they are forestalled from later objecting to the lack of independence of that person, because they've all agreed to the independence. And if those three cannot agree on any person in this country of nearly 1,500 million people, then I think there's no excuse for that. Thank you. Sorry for the interruption.
That's a very interesting suggestion, that a person can have essentially a veto power. That
yes,
without the consensus, there can be no appointment. And another interesting...
No.
Yes.
Yeah, I want to go beyond veto. I want to say that all three must approve. They must say, yes, we have confidence in this person. Right? And all three must say, we have confidence in this person, and be accountable for that. And there are such people. There are such people, and we know that many of them may well be retired judges. I would not be surprised if many of the people around whom there is a consensus would be retired judges. Now, if you take, say, Justice Venkatachalaya, former Chief Justice of India, he will never agree to be in any such position. But if his name is put forward, I think everyone will accept him as a very independent person. So the idea is that there should be three people, there should be a person who these three people affirmatively feel that they support to be election commissioners of India. That's not too much to ask.
But we kind of follow an unwritten rule that the election commissioners should be bureaucrats. And what often happens in the case of civil servants is that due to their long service in the government, they might be having some proximity with the people in power, and
exactly right.
They might not be inherently having that capacity or will to be independent and to be assertive. And we have seen that, for example, people like T.N. Sheshan are exceptions. We have never seen a powerful election commissioner like that after that. And when Mr. Ashok Lavasa, he took a firm stand during the 2019 elections, he had to face certain adverse actions from the government. So the government always has a mechanism to keep the civil servants under control. So maybe we need to think beyond this accepted notion that only civil servants can be election commissioners. That would be up to the selection committee and the screening committee, and it should be also include not only nomination but application. And nomination means all of us can suggest to the screening committee names for consideration to be election commission, and some can apply, so they can consider all these applications. And there are bureaucrats who are highly independent, long-serving bureaucrats who are highly independent, and who have tremendous, who enjoy tremendous confidence amongst the people. So I would not rule out bureaucrats, I would not rule out judges. I would simply say, let's have a process where, as Professor Sunny said, there's a screening committee, there's a transparent process for application, and let the screening committee shortlist, and let the committee of three people, the Prime Minister, the Leader of the Opposition, and an independent, eminent person, also chosen by agreement between the Leader of the Opposition and the Prime Minister, that the three of them choose election commissioners, that they have a full confidence in each of them. They must agree that, obviously implicitly they do, but that when we choose them, we have confidence in their independence and in their competence as well. As Professor Sunny pointed out, competence is equally important. Now, Justice Babu Joseph. So now coming to the aspect of enforcement of Model Code of Conduct. So what is your opinion regarding the importance of MCC and its significance in ensuring that the election process is fair and free and fair?
Hello. Model code of conduct that has been prepared based on the provisions in the election laws. And the Election Commission, within its wisdom, for the purpose of ensuring a free and fair elections, certain model code of conduct can be included, for which they have ample powers. Mere inclusion of model code of conduct will not be sufficient. That should be applied on an equal footing, not only to the ruling group, but also to the opposition group. Everywhere it should work properly. If a partisan attitude is taken, as now happens in the country, if a partisan attitude is taken, whatever be the model code of conduct, whoever be occupying the post of election commissioner or election commissioners, chief election commissioner or election commissioners, no purpose will be served. By the by, I also want to point out one more thing. Dr. Mohan Gopal was quite critical about the inclusion of Chief Justice of India. And Dr. Singh also has some reservations. But one thing I want to add in that region is this. The Honorable Supreme Court, not a division bench, by a constitution bench comprised of 5 judges, elaborately considered and finally arrived at a conclusion showing the necessity of inclusion of CJI as one of the members. And not only that, what is wrong with it? In the case of appointment of Director of CBI, Chief Justice of India is associating. In the case of members of Armed Forces Tribunal, the judiciary is associating. It is based on the law made by the Parliament. Similarly, under some other laws also, the judiciary is associating. The CJI has so many administrative powers. So, the CJI associates with a committee for selection of members of Election Commission. I don't find anything wrong in it. But what is the importance of a serving CJI? Retired persons, as put it rightly by Dr. Mohan Gopal and Dr. Singh, retired persons, there may be. If the Election Commission, you appoint a single person, if that person is totally good, no interference is required by anybody, it's a very good person, but it can only be a pious wish in the present scenario in our country. And the center is being ruled by a party. At that party's Prime Minister is included. That party's minister appointed by the Prime Minister himself is included. And one opposition member is also included. What is ultimately going to happen? From the experience, we can understand what is happening and what is now happening. Your question is that model code of conduct. If the commission is selected by any person or any person is appointed as the commission, if he is a very good person, no problem will be there. No problem will be there. If as Dr. Ambedkar rightly put it, here is a constitution. If bad people are dealing with that constitution, whatever be the strength and goodness of the constitution, nothing good is going to come out. Similarly, whatever bad the constitution is, if good people are dealing with that, only good will be the outcome. Like that, We cannot have a simple pious wish. Why not? There are good people, of course. There are good people, retired judges, yes. But the importance is that if a retired judge is associated and the CJI serving, CJI is not associated, there is subtle difference. There is vast difference. And who is appointing this retired judge? Who is selecting that retired judge? Eh? So that may not be an effective inclusion. If CJI is there, he has constitutional protections. He need not bow before the Prime Minister or bow before the minister chosen by the Prime Minister. So it is not a simple matter as put it by Dr. Mohan Gopal. A lot of consideration is required, because so many fields, now the judiciary is associated. The CJI is associated. Nobody is finding fault with that. I have already told you the example of CBI director, then Armed Forces Tribunal, so many other enactments enacted by the Parliament. The judiciary is associating with such a selection and appointment process. So, as far as model conduct is concerned, it is there. It's a very big book, very big one. But if you want to violate it, it is very easy for you. If I want to violate it, I can violate. If I am from the ruling side, no, I need not worry at all. My name is also will not be mentioned in the order. Who has, against whom this order, the star campaigner, is it sufficient? No notice is issued. That name doesn't find a place in the order. Is it an election commission? If such a commission is appointed by such a selection committee, such a search committee, what purpose will it serve?
You had mentioned the speech made, the complaints regarding the speech made by the Prime Minister. And in response, the notice was sent by the Election Commission to the party president. And that is something...
Not only that, that first speech made in Rajasthan on 21st April 2024, and till the elapse of more than 1 month, nothing has been done by the Election Commission. Throughout, that person continued his attack, continued his violation. Am I right? So that is what happening under such an election commission.
Now coming to the voting process itself.
Sebastian,
Yes.
Mr. Sebastian, since there were many references to me, I hope you'll give me 1 minute to respond to that. See, I don't disagree with the spirit of Justice Babu Mathew's comments, but my concern is that if I want to challenge the appointment or selection of an election commissioner, I should not put the Chief Justice of India or the CBI director, for that matter, or anywhere where the Chief Justice or a judge of the Supreme Court is involved in the selection. I don't want to reduce them to having to recuse themselves from considering that case or that application, because they were party to the decision that was being challenged before the Supreme Court. So these two functions of selection and judicial review are mutually incompatible. And therefore there is a conflict of interest between these two functions, and so we should spare the judicial institution from being put in such a conflict of interest, or we should say there is no judicial review of the selection of CBI director or Chief Election Commissioner. That is the committee has the last word, and the Supreme Court of India cannot review it, which we cannot do under the Constitution. So the judicial function and the executive function should be placed in such a manner that the judiciary is not in a position to be able to conduct a review of the commission, because they themselves, the sitting judges, were implicated in it. Last point, Justice Babu Mathew correctly described about the kind of actions that the Prime Minister takes. We also know that this is a Prime Minister who managed to reduce a Chief Justice, just retired Chief Justice of India, to become a member of Parliament of the Rajya Sabha, sponsored by the ruling party. So do we want to have such people selecting the election commissioners and bring the whole institution under a cloud simply because they were put in that role? Not because they were Chief Justice of India, but you gave them a rote of selection, which is not a judicial role. Selection into the judiciary is a judicial role. But selection to other branches of government is a role of those branches of government which should be subject to judicial review. So I'm just trying to protect the dignity and independence of the Supreme Court, and I believe, and simply because a 5-judge bench decided something, we cannot accept it as right. The Supreme Court itself set aside ADM Jabalpur, which was also a 5-judge bench decision, including some of the most distinguished judges of this country. And the Supreme Court, set it aside. So, so we cannot say simply because there's a judicial decision that's necessarily right. That's not democratic. And ultimately, we are here to have a democratic approach. We can't say because the judiciary considered it, therefore it has to be right. We are all entitled to our own view. The question is the view I'm presenting rational or not? The answer is not that the judiciary has made a decision on it. That's not the answer certainly in an academic seminar. Thank you.
Yes.
Regarding the action of the Election Commission regarding violation of Model Code of Conduct, here also I am sticking on my earlier point, that is transparency. That is very important. If there is an allegation mooted by leaders of the national party, any national party, regarding the violation of Model Code of Conduct by the Prime Ministers of such persons, definitely the Election Commission should take a decision, and that decision may be a reasoned one. Yes, this complaint is baseless. Why? That may be mentioned. That is my point. That may not be kept secret like atom bomb construction. Election Commission should take the decision, and that should be a reason.
So I think, so we had a very different kind of perspectives on the topic of appointment process itself from 3 learned panelists, and that is the beauty of discussion. We can have multiple perspectives. So I think we can move on to the next point, that is the voting process. So the electronic voting machines are under a lot of public scrutiny. There is a section who raises a lot of doubts regarding the possibility of tampering.
Mr. Sebastian,
yes.
Can I have 1 minute on this Model Code of Conduct?
Yes, sir.
Because I did not get to speak on that. I was just responding to the comments made about the earlier point. On the Model Code of Conduct is again a good example. The Supreme Court is now taking what it has itself seems to have described, according to reports in LiveLaw and other reports. I have not seen the remarks or the judgments myself, but certainly it may be remarks made from the bench that the court should have some kind of a hands-off attitude towards ongoing elections. And I would like to suggest that that's really not, not enough to protect the independence of the election. That where on a Model Code of Conduct matter, the Election Commission fails to act promptly and effectively to ensure independence of the conduct of elections, the Supreme Court should promptly be open to entertaining petitions and reviewing that independently and taking a view on whether the Election Commission has acted lawfully in handling the complaint against the Prime Minister, for example, in this case. I think that should be subject to judicial review. It is, in principle, subject to judicial review, and there should not be a hands-off attitude. The Model Code of Conduct can be improved and so on, but at the minimum, it must be enforced. And if the Election Commission, bona fide or mala fide, fails to implement it and enforce it, and there is any person who has a complaint that reasonable complaint that the Election Commission is failing to discharge its duty, then we should be able to go to the Supreme Court. And at that point, the Supreme Court should not be affected by the fact that these commissioners have been appointed by the Chief Justice of India, so they are competent people. They should be able to take an independent view and say, okay, they have not done their job, and they should be asked to do it. So I would say that we need judicial review, prompt and effective judicial review of the actions of the Election Commission on enforcing model code of conduct before it is too late in the election. Thank you.
But how, as far as the present complaint is concerned, in fact, a petition was filed before the Supreme Court seeking the action by Election Commission against the speech of Prime Minister and various other parties. And the Supreme Court did not even hear the petition for even 2 minutes.
That's what I'm saying they should. I'm saying I agree with you. They should hear it.
As soon as the matter was taken, the court said either you withdraw or we dismiss with cost.
Yes. I agree. I think that, ultimately the Supreme Court is a guardian of democracy, the guardian of the final forum to which we can go to complain if the Constitution in spirit or in letter is violated. So they must listen to it. They can dismiss anything that's not substantive. But if there's a substantive argument that is made with evidence, then I think the court is obliged. It's obliged. That's why judges are paid a salary by the public.
Generally, the court's view is that you challenge it in an election petition after the results, so that. But the thing is that election petitions.
Yes. And also, if it is a speech by someone like the Prime Minister that affects many elections, then you want to correct it immediately, because ultimately you want to safeguard society and you want to safeguard the integrity of the election. So if it's a serious matter, then the judiciary must intervene and protect the integrity of elections. Is my personal view.
Right. So now we can move on to the next aspect, I believe.
Yes.
So that is regarding the EVMs, electronic voting machines. So there are certain doubters who question the sanctity of EVMs. But now the Supreme Court has said in the recent judgment that EVMs are tamper-proof, they cannot be manipulated. The court has expressed this confidence. And along with that, there was this question of verification of VVPATs, the voter verifiable paper audit trail. So now the practice is that the Election Commission, they randomly pick up 5 booths, and there is a random verification of 5 booths of the EVM and VVPAT. So do you think that there is a need for more verification, or should the Election Commission's argument is that this will delay the result, delay the counting process? So they are basically raising practical issues. That is the main objection by the Election Commission. So what is your take on that?
There are very serious criticism against the use of electronic voting machines in India. In the world, there are about 120 countries. They are democratic countries. Elections are taking place. Out of them, only about 25 countries are using these electronic voting machines. Unlike India, in those countries, certain added assurance is also there. A major criticism, I can put it in a simple way, a reading of one paragraph. Serious doubts about safety, accuracy, reliability, and verification of elections through electronic machines are raised throughout the world. It is surprising that even some in major developed countries of the world do not rely on the technology of EVMs. Many countries of the world, including England, France, Germany, Netherlands, and the United States, early advanced countries, have banned the use of EVMs. The only form of e-voting in the USA is via email or fax. Technically, the voter is sent a ballot form, they will fill it in, return it by email or fax, a digital photo of the ballot with their choice marked. So, the criticism is widespread. And in the Indian scenario, we know, in India, about 21 millions of women are not included in the voters list. They were not registered as voters. Majority, a sizable portion of the voters in the country are uneducated, illiterate, coming from poor strata. And there is no sufficient mechanism for overseeing or ensuring the genuineness or proper functioning of these EVMs. So, the criticism that as far as India is concerned, the suitable mechanism is the old ballot paper. Whatever be the time taken or whatever be the expenses incurred, some assurance will be there, the people are electing. Otherwise, you see, what is happening? What is happening at the hands of Election Commission? What is happening? So, there are various reasons for doubting the genuineness. And you might have heard about 1 or 2 years back, the first elections in India, this, the 2014 elections, the EVMs were manipulated. Was the allegation, serious allegation raised? Whether it is true or not, I cannot certify. But serious allegations were there. As far as I am concerned, old ballot paper is more suitable to the Indian conditions and more suitable to the particular type of voters in our country.
Dr. Sunny, do you also share Justice Babu Joseph's skepticism about EVMs, particularly since you have observed elections in other countries and also in that, in the light of your experience as an international
Yes,
observer?
even now, as pointed out by Honorable Judge, vast majority of countries are adopting this ballot paper system. And to the awareness of the students, I would like to point out one fact that earlier in the RP Act itself, the term ballot was used. And in AC Jose versus Shivampilla, without amending the Act, electronic machine was introduced. Then, first in the case came before the Kerala High Court, then Honorable Justice Kochuthamman heard the petition and he said, ballot means any device for recording vote. So it will include, yes, but Supreme Court took the different view. Then this RP Act was amended. That is the history. Then after the introduction of this electronic voting system, there are so many complaints. Then next step was this adoption of the strategy of this VVPAT. So now we can see whether the same thing is recorded in the ballot paper or not. Now, the problem is that only a small percentage of VVPATs are counted. My suggestion is that all VVPATs may be counted if there is an election petition. Through election petition, one contesting candidate or any other elector contended that we have serious doubt regarding the functioning of this electronic voting machine. So, all VVPATs must be counted, then that may be done. So, then there may not be any question of delaying the election and result and other things. But suppose in one election, there are so many election petitions and court ordered to count all VVPATs and now it is proved that some manipulations happen, then the authorities will be forced to correct it or
2019 election,
That is my suggestion. That through election petition, counting of VVPATs may be made available. Okay.
It is only for some chosen.
As chosen constituencies.
So wherever there are doubts, wherever there are disputes regarding the results, VVPATs can be counted through a judicial order. That is your view.
Now, in the conventional system also, that is happening in the case of this tendered order. Then there may be search of all ballots for locating locating the particular ballot by using the counterfoil.
So Dr. Mohan Gopal, what are your views regarding this issue?
Yes, see, I think this is an issue on which we have to first of all bear in mind that we cannot compare India's election to any other election in the world because of sheer size. We had, I think, in 600 million people, that is like twice the, almost 350 million or so in the United States population, but about almost twice the population of the United States as actual votes cast, not the eligible voters. So it's a massive exercise. And so I think there is no doubt that we should use electronic voting machines, but with necessary safeguards. And I think one of the safeguards that we already have is that every single machine in the country, in every polling station, is verified in the presence of all the polling agents through a mock polling of something like 40 or 50 votes are cast. Mock votes are cast and the VVPAT is checked against the machines. The machines electronically are secured so that they cannot be interfered with by any remote or satellite or other means. There is no hardware that will permit that to happen. And and if during the mock poll there's any problem, then the machine is immediately replaced. So then after that, if any voter sees that we've all voted, if we see that our physical, the VVPAT is not matching with the votes that we've cast, then we can draw attention to the polling officials and they will take action under it. So there are safeguards. We need more safeguards, and I agree with Professor Sunny's suggestion that we should have physical verification of 100% then we might as well abolish it and simply count the physical ballots. If we have to count all the ballots, then why have electronic voting machines? And we know that, so what we are saying is that we cannot rely on just ballots. We want to have electronically printed votes rather than marked directly. We know what used to happen when there were physical ballots. A lot of manipulation can take place. Whatever the system is, it is open to manipulation. We must recognize that. In all countries in the world, systems can be manipulated in one form or the other, but we have to limit it. So as Professor Sunny has said, if there is a close contest, and already, I think it was in 2021 or so, Election Commission has issued some guidelines on what happens in close results, what kind of verification must take place when close results come. So there are already some of these protocols in place, which I'm not getting into in detail. But so there is that I think, and there's nothing preventing even now in close contests or disputed contests to count the votes again. And we've seen that happen in election petitions. There's recounting and so on. So the safeguards are present. I think for me, the question I have in my mind is, if electronic voting machines were such a big issue, how come the then ruling party suffered such a devastating result in 2014 when all the institutions were under their control? They had ruled for 10 years. The election commissioners were all appointed by them. All the officials were appointed by them. EVMs were used. And the ruling party came to a disastrous defeat. So then it may not be the machine, but it may be oversight over the machine. That is a problem now. We have seen videos of some ruling party members voting 8 times and so on and so forth. So that's a misuse of the machine, abuse of the machine. And maybe we should tackle that. That's a serious problem. I agree it's a serious problem that the machines could be tampered with and made to malfunction or abuse, and that should be tampered with. But should we throw the baby out with the bathwater? I think we need a much deeper debate on this issue. And let's also not forget in 2019, compared to 2014, very few people recognize this, but the ruling BJP NDA actually suffered a fairly significant setback compared to 2014. They lost seats in a number of areas with the same machines. So it is possible that the machines are okay, they're working okay, there are safeguards, there will be problems, but they are looked at, and we need to improve the quality of the machines. We need to improve the physical quality and control over the machines. But I think more importantly, we must have election commissioners who are independent, and an independent election commission that will ensure that no machine can be physically accessed to be abused and manipulated, as we have seen in the video of somebody taking a machine and voting 7 times or 8 times on it. That's not an indictment of the machine. It's a failure of the mechanisms in place for safeguarding the integrity of the election process.
Okay, so I believe we can have a short open forum kind of session also. So any member of the audience, if they want to raise a query, they can raise. And if they want to raise a query to any specific panelist, they can specifically mention that also. Yes.
Good evening. Hello. Hello. Good evening to the panelists and the various participants present here. I am Keshav from TNNLU, a second year student. I presented my paper last day, and my question is, I've had to go through that whole judgment written by K.M. Joseph sir, the Anup Baranwal vs. Union of India. The whole 289 pages I've read. So what I found in the judgment was, firstly, they said that one important aspect was they laid the recommendations on the basis that there existed a legislative vacuum that had to be filled. That was one basis why the whole composition was given by the Honorable Supreme Court. And what I find is, the supreme leader of our country had made some derogatory statements, and the election commission, one of the spokespersons said, we are not making any comments on it. So is the election commission allowed to do such things? Like, I had a doubt in this regard, sir.
Hello. Such an allegation has not been raised purposefully against the Election Commission. Certain things we will conclude from the attending circumstances. Very serious hatred speech has been made repeatedly by the prominent leader. And immediately complaint has been given by the opposition leaders. And time was granted, and repeatedly time was granted for answering. No notice has been issued to the person who violated the model code of conduct or that committed the alleged corrupt practice. No notice has been given. Notice was given only to his party president. And after elapsing a month in between, from the first date of commission of these things, a lot of speeches similar type had been made by the same person without any fear, fearlessly, boldly. He has completed. In the history of this country, from 1947 onwards, nobody dared to render such hatred speeches during elections. So, from the attendant circumstances and from the ultimate order issued by the Election Commission, we can understand it is necessary for the victory of the ruling party to continue such violations. So indirectly, we have not taken a decision. We are waiting for taking a good decision. And they took more than 1 month for giving a verdict. And that verdict, that order was also containing nothing. Doesn't contain any good thing. So from the attendant circumstances, one can infer indirectly the Election Commission permitted to continue the violation of this the model code of conduct and commit that yes.
Hello everyone. I have a series of questions. Two questions. One of them is Election Commission of India a body which is inherently flawed? I'm asking this in specific context to Article 324, which talks about the removal of the election commissioners. So it cannot be done unless it's a recommendation of the CEC. And it has happened only once, I believe, when the CEC actually moved ahead in 2009. So is Election Commission not using its power fully, or is it made in such a way that it's inherently very flawed? Also, in considering the fact that regional commissioners have almost never been appointed except once in 1958. So, are we underutilizing the Election Commission? Is Election Commission as a body itself not fully utilizing its power? That's one question. And of course, the other one is about election commissioners given a role lesser than that of the CEC. Is it needed? Is there a flaw in that? Is my question, sir.
You are asking whether giving CEC a primacy, is that affecting the functioning of Election Commission? Okay. Dr. Mohan Gopal, would you like to respond to that query?
Could you just repeat it for me so that I'm sure I heard it, but I just want to make sure I heard it correctly.
I believe the questioner is asking if giving the CEC a bigger role than the other two election commissioners, is that affecting the functioning of the Election Commission? I believe that is your question, yes.
Yes. No, I think one of the issues is that Election Commission is almost a different branch of the state, actually. I don't want to, I'm using the word branch in a very limited way, because it is independent. See, let us understand that even the president is actually head of state for purposes of international relationships. But if you look at the constitution, the president is the head of the executive. He's not the head of the judiciary or the legislature. He's the head of the executive. So the executive is ultimately chosen through an election. And the judiciary's role is to adjudicate disputes. So when I say they must look at current issues, it is simply to decide the legality of the decisions. Actually, the role of the judiciary is perhaps very clearly set out in the definition of fact and issue in the Evidence Act, which says it is the determination of the existence, non-existence, nature or extent of right, liability or disability. And then once that is decided, then the right must be enforced, the liability must be enforced, and so on. So we go to the judiciary only to establish the existence, non-existence, nature or extent of right, liability or disability. We are not going to the judiciary as a substitute for the election commissioner to decide how elections must be conducted, but to look at the legality of the decisions of the election commissioner. So the election commission, firstly, I think we must understand, is distinct from the executive and the legislature. So but in order to choose them, the parliament and the legislature and the executive come together and choose them. Once they are chosen, then the parliament and the legislature are the ones who are being formed by the elections. So if you give them a power to remove them, there is a conflict of interest. Then they will ensure that they'll remove the election commissioners who they do not want and put in the election commissioners that they want. The judiciary's role is not to appoint or remove, but to look at legality. So you're left with some kind of a mechanism where the election commission itself decides whether to remove a member or not. Or you can have, in the case of judges, and there have been only 4 or 5 instances of this kind. I was privileged to be a member of one such exercise, where under the Judges Inquiry Committee, High Court judges and Supreme Court judges can be removed only by Parliament on the basis of a report of an independent committee of sitting Supreme Court judge, sitting Chief Justice of a High Court, and a sitting jurist. And I was the so-called jurist on one of these committees. And it's a very, very effective and good mechanism. I have personal knowledge of that. So, but even that is not possible here because Parliament is an interested party in the Election Commission. So I think the idea that ultimately we have to find a mechanism where within the Election Commission there's a decision to remove or not to remove, I think is almost inevitable. Now the question is how to do that. Now you put it on the Chief Election Commissioner because under Article 324(2), you need not have more than the Chief Election Commissioner. So maybe the reform must be to see whether a majority of election commissioners, all of who are chosen in the independent way that I suggested, they have the power to remove other election commissioners, rather than only the Chief Election Commissioner for reason, not for good reason, and that removal can be subject to judicial review by the Supreme Court. That will then, if it's an illegal removal, they'll strike it down. Even now, if a Chief Election Commissioner removes an election commissioner, that must be and is subject to judicial review. That will, and the Supreme Court will ensure that it is done lawfully and constitutionally. So I think it's a complex question, and maybe we don't have the details right. But I am not convinced that there should be any mechanism to remove an election commissioner except through by the election commission itself in some appropriate manner.
Justice Babu Mathew, would you like to?
Hello. I may add 1 or 2 sentences. The person who asked the question raised a doubt that in the matter of powers, there are differences between the Chief Election Commissioner and the election commissioners. Is it so? That is your doubt?
Yes, sir. Regarding the removal.
Not regarding the removal only,
Primarily,
or exercising the powers.
so primarily the removal because it's mentioned as far as I know.
No, removal that is there. All the election commissioners, chief election commissioner, as well as the election commissioners, have equal powers in the discharge of their duties. When they sit together for deciding matters, the chief election commissioner will preside over the meeting. It has been specifically explained and laid down by the Honorable Supreme Court in T.N. Sessions case. T.N. Session challenged the appointment of 2 more election commissioners. In that case, it is clearly clarified that Chief Election Commissioner as well as the election commissioners will have equal rights as far as the powers of the commissioner is concerned. In the case of removal, the Honorable Supreme Court, by the recent Anup Baranwal's case, the Supreme Court expected a hope that the central government will consider for granting such a right to the election commissioners as well, that the chief election commissioner can be removed by way of an impeachment, as in the case of a Supreme Court judge. Such a benefit also should be extended to other election commissioners. Such a hope has been expressed by the Honorable Supreme Court. As far as powers are concerned, there is no disparity. But in the Appointment Service Conditions Act, the Government of India, the Parliament, did not go into that aspect. That's all.
I think we can have one final question. There is a lady behind. She,
Sir, I have to ask about the reliability of common people on the elections in the future. In the last Lok Sabha elections also, we saw that many villages boycotted the elections as a whole in Tamil Nadu, Gujarat, etc. So this has been a recurring even now, and more villages have started to boycott villages. So do you think that the people's belief on the process of election is reducing over years?
I don't think so. And my bona fide belief is that people's confidence is increasing. Then regarding the boycott and other things, that matter may be taken up case by case. Who is behind this? There may be somebody. That is my personal point of view.
maybe not voting is also a form of voting, in that sense. So we have the option of nota is there. So instead of going to the booth and pressing nota, they are like sitting at their home and exercising their nota option. Maybe that we can see it that way also.
Hello.
Hello. My question is to Mohan Gopal sir specifically. I am partially agree with the voting. It's very difficult to go back to the paper ballot. But I would like to ask that, is it?
Hello.
Hello. So I am audible, sir. Hello. Hello.
Yes. Hello.
Hello.
I cannot hear. I cannot hear.
Okay. Am I audible now? Hello? Hello.
Sir, are we audible now?
എനിക്കൊന്നും കേൾക്കാൻ ഒക്കുന്നില്ല.
Hello, sir. Hello, hello.
Hello? Hello?
Hello.
Okay.
Sir, can you hear us?
Hello. 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 Can you hear me, sir? Okay. Sir, my question is, hello. My question is to Mohan, sir. Sir, I agree with you that it's going back to paper ballot is not easy, of course. But do you think that there is a lack of transparency? We don't know what the hardware is used, what the software is, who is the program, what is the algorithm behind it. In that area, there must be a chance for a lot of manipulation. I think there must be some transparency in those things that Election Commission has never disclosed anything about the hardware or software what are they really using or instrumenting to held with this all the election, how the election is held with this total. And even though VVPAT, yes, I agree that VVPAT is counting, but that also works on some software that when we press a button, it prints. This is also a software, and there is a chance for and we don't know about that software's algorithms and everything. So do you think some sort of transparency has to bring into that?
Thank you, Mr. Prashant. I think it's I totally agree with you. There must be transparency, and we must know. And I think we are talking of standalone machines. They are not connected to any other machine. They have no hardware to connect them, remotely to any other machine. They're not physically wired to connect to any other machine except the printer. So you just have the printer and the voting machine. So the software must, I would imagine, I'm not an engineer, you'll know better, but I would imagine that the software must be extremely simple and simply very, very mechanical, that you press a button and there are only 10 or 20 whatever, a very small number of choices, and you press a button and it prints a corresponding paper. It must be very simple. And but they must be transparent about that. They must insulate the hardware. But what they do is, in every single polling booth in the country, before polling begins, there is a mock polling where all the polling agents of all the candidates are able to attend, and they actually cast votes. I think something like 50 votes or something is what someone who works on it told me. Then you can watch, and they watch for the various different candidates. They vote, and they see whether all of those are the corresponding VVPAT. The printout corresponds to the button that was pressed. And if that machine shows any malfunction, then it is immediately replaced. So, and then the voting begins immediately. This happens only just before the voting. So there are some safeguards, but your essential point is fully right. There must be complete transparency. We must make the machine as simple as possible, as dumb as possible. It should not be a smart machine, and as possible. But even if that is the case, we still must ensure that it cannot go into the wrong hand. For that, we depend on the election. And that's where the Election Commission's independence becomes crucial. And that's where there's a real suspicion. Is it going into the wrong hands? And are people who are not voters actually operating it and recording votes? I think to me that's the big concern. The other malfunctioning, it happens, there is a procedure. If it happens again, we should all be alert and we should be very proactive in identifying the difficulties.
So we can have one more question. This will be the final question.
Good evening, sir. Let me quote one sentence from the last speech of our father of drafting, Dr. B.R. Ambedkar. In his speech, Ambedkar Sahab mentioned that the democracy in India is only a top dress on the Indian soil, which is essentially undemocratic. So, in the question, 75 varsham mumbu, such a big man who visualized the things which is happening after the 75 years. So I want your opinion about the quoting of the great visionary Dr. Ambedkar.
Is it direct? I'll be happy to answer this question, Mr. Sebastian, if you permit me.
Okay, sir. Sure, sir. Sure.
Because I wanted to make one or two broader points very quickly, and this is exactly correct. I thank the questioner for this very good question.
Thank you, sir.
I think Dr. Ambedkar is very, very correct. We cannot look at free and fair elections in isolation. Right? I would recommend to the students who are interested to visit a website which is called V as in victory I'll just give you DE. The name of the site is DE is VDEM, V-DEM, VDEM, Dem for democracy, DEM, and the name of the site is v-dem.net. Now, this is a site of the University of Gothenburg in Sweden. And they every year publish a democracy report. It is one of the largest databases in the world of this kind of social data. And it looks at over 130 countries and is looking at the state of democracy and the state of autocracy in the country. And what they find in the 2024 report, what they find in the 2024 report is that India ranks 104 out of 179 countries in the liberal democracy index. In other words, India is one of the weakest democracies in the world. They classify democracies and autocracies into 4 categories. One is called the autocracy into 2 categories. Closed autocracy, which means no elections at all, like say in Burma. And electoral autocracy, where there is elections, but there is no freedom of expression, speech, no of association, no political activity. It's called electoral autocracy. So closed autocracy and electoral autocracy. Then on democracy, there is electoral democracy and liberal democracy. Electoral democracy is where there is free and fair elections and the minimum safeguards for safe elections and freedom of association, freedom of speech are present, constraints are present, judiciary is active, and that is put as an electoral democracy. And then there is a 4th category called liberal democracy, which is what Dr. Ambedkar was talking about, where the top soil of democracy and the bottom soil of society are both democratic, and there are effective freedoms and effective rights. So if you take this closed autocracy, electoral autocracy, electoral democracy, and liberal democracy, then India in this category, shamefully, is now an electoral autocracy. India is not considered a democracy by this independent, university-based very, very detailed research. India is today an electoral autocracy because it lacks, there are elections, but there are no freedoms of expression, association, speech. And Justice Mathew has, in a very eloquent way, described for us the kind of challenges that we faced that has pushed us from being a democracy into an autocracy. And this report says that you need not only an electoral democracy, this is actually giving flesh to Dr. Ambedkar's comment. You need to have protection of individual and minority rights against the tyranny of the majority. And here we are seeing an attack on the minority, on Muslims and Christians at scale. So we need a liberal political and social order. We need participatory democracy where people have meaningful role in decision-making and law-making. We need deliberative democracy where issues are openly discussed in a rational and open manner and not in an emotional manner, but in a reasoned manner. We need an egalitarian society where there is equality, not only between groups, but also between individuals. We need a consensus-based majority rule, that minimum a majority must rule, but the majority should not rule except on the basis of consensus between majority and minority. I would add to that what Dr. Ambedkar emphasized in the 1930 Roundtable Conference in London, where he said that we need not only an electoral democracy, but the depressed classes demand is we must have representative democracy where all communities, Dr. Ambedkar's words, have due and adequate representation in the legislature, in the executive, and in the judiciary. And today, we don't have that. India is ruled by an oligarchy of 4 communities at the national level who monopolize all the top positions in the Indian state. And in our own state, we are ruled by an oligarchy of 3 communities that basically monopolize most of the top positions in the legislature, the executive, and the judiciary. So Dr. Ambedkar called this an oligarchy, not my word, Dr. Ambedkar's word. He said we need representative democracy with due and adequate representation of all communities in order to counter this and dismantle this oligarchy. It's only when we have representative democracy, social democracy, economic democracy, and a liberal political order and a liberal social order, well, we have really free and fair elections. Until then, we can tweak EVMs, we can tweak the election commission, but this is elections taking place in an oligarchy-ruled electoral autocracy as determined by this University of Gothenburg Institute of Democracy. But they're very detailed reports. I would encourage those students who are interested to access that site and read the very detailed reports for yourself about the very pathetic state of democracy in India, which is, we say we are the largest democracy in the world, but the largest research institution on democracy is calling us an electoral autocracy. This is the irony. Thank you, Mr. Sebastian.
Justice Babu Mathew, would you like to add? Okay. So I think that will, our session has come to an end. Yes.
I am not saying anything about the topic, but I must appreciate the action taken by the Kola Union for organizing this type of program. I think this is an excellent program. This is a role model for all the institutions because very well-arranged program with the support of principal, teachers, and others. I once again congratulate the chairman, Farwan, and other office bearers of the Students' Council. Thank you very much.
I also congratulate each and every one of you for organizing such a wonderful national conference. And this will be, can be followed next year's, coming years also. And best wishes.
Thank you so much to all the panelists. Justice Babu.
May I also intervene to congratulate and compliment the Students' Union and the students for organizing this outstanding event. I know a huge amount of work has gone into this, and I'm sure you would have learned a lot, and it's been a very enriching experience for me. Let me also express my appreciation of for the participation and contribution of Justice Babu Mathew and Professor Singh. I have enjoyed listening to them and discussion. Thank you so much. Very grateful to you for this opportunity.
Thank you so much to all the panelists, Justice Babu Mathew P. Joseph, Professor Dr. K.C. Singh, and Professor Dr. G. Mohan Gopal, sir, for engaging us all in this discussion. And a special thanks to our moderator, Mr. Manu Sebastian, for smoothly facilitating the whole panel discussion. Once again, I thank you all. Now, I request our faculty, Ms. Minnie Paul, ma'am, to kindly present the memento as a token of appreciation to the panelists and our moderator. Ma'am, please. I request Justice Babu Mathew P. Joseph, sir, to kindly come forward and receive the memento. Now I request Professor Dr. K.C. Singh, sir, to kindly receive the memento. Our moderator, Mr. Manu Sebastian, sir, kindly receive the memento. Professor Dr. G. Mohan Gopal, sir, we have prepared the memento for you, and we will be physically sending you the memento. Sir, you're not audible. Just a second.
Good job. I think we should all give him a great round of applause.
Thank you so much, sir. Thank you to all the participants. Now, I request our BSSE joint convener, Nandan, to formally propose the vote of thanks.
Respected dignitaries on the dais, teachers, advocates, and my dear friends. Our collective effort over the past 3 days has contributed to creating an intellectually stimulating atmosphere on this campus. In honor of 150th anniversary of this institution, the College Union, in association with Bhagath Singh Study Circle and the Law Journal Club, has successfully organized a significant national event. This event has garnered attention from national media, scholars, students, and advocates. We have witnessed the keynote event of this conference, the panel discussion on the topic, Democracy in Peril, Are Our Elections Free and Fair? Is definitely a topic of the utmost importance in the current scenario. Discussing and deliberating on this crucial matter in contemporary scenario is which makes this even more relevant. As in recent days, we witnessed an ECI which exists without exercising the constitutionality granted powers to ensure a free and fair election. Therefore, I do not consider this discussion merely as an academic discussion, but a social message upon which every citizen shall contemplate on. We are so privileged and honored to have such distinguished panelists today. At the very outset, we would extend our gratitude to the former Judge, High Court of Kerala, Justice Babu Mathew P. Joseph, sir. Thank you, sir. Next, we would like to thank former Director, National Judicial Academy, and former Director of NLSIU, Bengaluru, Professor Dr. G. Mohan Gopal, sir. Thank you, sir. I would also like to extend my gratitude to former Vice Chancellor of NUALS, Professor Dr. K.C. Sunny, sir. Thank you, sir. Next, I would like to thank the moderator of the session, Managing Editor, LiveLaw, Manu Sebastian, for exceptionally moderating the session. Thank you, sir. The student-driven conference would not have been possible without our mentors, Dr. Girishankar, sir, former Associate Professor of Government Law College, Ernakulam, thanking him in his absence. Advocate P.V. Dinesh sir, Senior Lawyer, Supreme Court of India, and the co-founder of LiveLaw. We are also thanking him in his absence. Advocate Manoj Kumar sir, the State Attorney, Government of Kerala. We are also thanking him in his absence. And the Secretary of the Alumni Association of this institution, Advocate Sanjay sir. We are also thanking him in his absence. Next, we would like to thank our faculties, Premsi ma'am and Minipol ma'am, for cooperating with us throughout the program. Thank you, ma'am. Also, the nationwide reach for the program was achieved with the support and effort of our media partner, LiveLaw. Thanks the whole team. On the behalf of College Union, Bhagat Singh Study Circle, and the Law Journal Club, we would extend our wholehearted gratitude to each and every volunteers for the continuous and unconditional support. Thank you, volunteers. Last but not the least, we are thanking each and every participant who has been there in all these sessions and which created a big success. Thank you all. From the river to the sea, Palestine will be free.